We can start.
Right. Thanks, Priyanshu. Hi, everyone. A very good morning. Uh, Thank you for being here on a Saturday morning. I hope you all are doing well. My name is Tejas Vinder, and I am a legal associate at Cyrilla Machan Mangaldas. I work with the ESG practice in the Mumbai office, and I'm part of a team of two. On behalf of Legal Specs and myself, I welcome you to this 8 week course on mergers and acquisitions. And as you may have been intimated already, we will be covering three fundamental aspects in today's session uh, as part of this introduction class. First is a quick introduction to what mergers and acquisitions deal structures look like. A second, it will be what the present legal framework is. And third will be the real world negotiation and drafting techniques. Apart from this, of course, if there are any questions over the course of the lecture or after the lecture, I will be happy to take them. So let's get started. Before we get on into understanding what M&A deal structures are and what they ideally look like, can someone uh, attempt to tell the difference or give all of us an insight into what the difference is between a merger, an acquisition, and an amalgamation, at least in the Indian context? You can unmute and speak, whosoever is aware.
Merger means two companies join together and form a new company. And acquisition means a larger company acquires the smaller company. And amalgamation means two companies join and form a new company. But in merger, they may take the name, existing name, or they can choose a new name. But in amalgamation, the new name will be selected.
Okay, that's fairly right, Elita. I don't know if I'm pronouncing that correctly. Uh, Fairly right, Elita. Yeah. Anyone else?
So in case of mergers,
Mhm.
one company's name is removed from the ROC,
Okay.
and in case of yeah, and in case of acquisitions,
Mhm.
the one company remains as a subsidiary of the parent company,
Fair
the
enough.
acquiring company.
Fair enough. That is definitely another point of difference. More on the procedural aspects bit of things rather than the conceptual aspects bit of things. That's right, Ashu. I'm not saying what you're saying is wrong. Looking for a conceptual difference. I think Elita almost gave correctly. Okay, let's not spend more time on this. Let me just give it to you. Elita was, I think, 90% right in what she said. A merger will ideally is a legal consolidation of two entities into one, where one company, as Elita mentioned, merges into another and loses its separate identity, and the surviving company that therefore is formed or therefore exists assumes the assets, the liabilities, as well as the business operations of the merged entity. So ideally, in the case of a merger, approvals will be needed from the NCLT, the shareholders and creditors, as well as in case of any antitrust concerns, or in case of the companies being listed, or if there is a foreign involvement that exists, you would need approvals from the Competition Commission of India, the Securities Exchange Board of India, and the Reserve Bank of India, respectively. So to explain it to you by way of an example, if company A merges into company B, company A ceases to exist while company B continues. So many a times, I mean, there can also be an understanding that an entity C is created as a result of a full merger of A and B. But mostly in an Indian context, when a company merges into another company, the latter is deemed to continue to exist. And of course, as may be agreed upon by the companies that do over the course of the merger, if the resultant entity is a separate entity altogether, then as Ashu had indicated, a name change will be required before the registrar of companies. An acquisition, on the other hand, refers to one company purchasing what we call a controlling interest or substantial assets of another company, and the acquired company may continue to exist independently depending on the nature of the deal, as Ashu mentioned, as a subsidiary. So usually there are two types. It's either a share acquisition or an asset acquisition. So share acquisition implies buying a majority of shares in the target, and asset acquisition implies buying specific assets like plants or technology or maybe even customer base. So an example for this can be if company A, say, acquires 75% of the shares in company B continues as a separate identity, but it is now controlled by company A. So as Ashu mentioned, company B will continue to exist as a subsidiary of company A with a separate legal identification, just to add on to what Ashu mentioned. So now with merger and acquisition clear, let's come to amalgamation. Amalgamation is a broader term that is often used interchangeably with a merger, but it technically refers to two or more companies combining to form an entirely new company, which is where I think the conceptual clarity that Elita brought out went a little wrong. Because both the original companies in an amalgamation dissolve and a new entity emerges. So this is where Elita's example comes as relevant, where company A and company B amalgamate to form company C, and then both company A and company B cease to exist thereafter. So if you want to take note of this for the purposes of conceptual clarity, note it down as on the basis of 5 parameters. So first, for legal identity, in case of merger, there is one company's legal identity that survives. In case of an acquisition, both the company's legal identities may survive. In case of an amalgamation, both the identities of both the companies dissolve. In case of the second parameter is control. So in case of merger, it is usually mutual. In case of acquisition, one gains control, obviously the acquiring company does. And in case of amalgamation, it is an equal combination. As far as the nature of the transaction goes, in case of a merger, we can ideally call it a consolidation. In an acquisition, we can call it a takeover. I mean, that is to say, in case of an acquisition, you can call it a takeover. I'm sorry, I correct myself. And then in case of amalgamation, we can call it a formation of a new company. So ideally for regulations, you will have for mergers and amalgamations, you'll obviously have to look at Section 232 of the Companies Act of 2013. And for acquisition, it's the Companies Act coupled with the SEBI Takeover Code. And what the last parameter, which is the commonality that will exist, is in case of a merger, it is a corporate restructuring. In case of an acquisition, it is strategic control. And in case of an amalgamation, you can say it is common in, perhaps PSU consolidation, that is public sector undertaking consolidations, or in tax planning. So with this indicated, let's quickly jump on into understanding what M&A deal structures look like in India. Oh, wait, before that, yeah, if there's any other thought that anyone would like to add to whatever I just mentioned, please feel free. I'll wait for a minute. Okay, I see that as none. All right, let's get started then. So mergers and acquisitions refer to a broad set of transactions where, things like ownership, management, or operating control of business is consolidated or transferred. So at the heart of every M&A transaction lies what we call its deal structure, which determines how the transaction is executed, both legally and financially. So deal structures not only affect the method of transferring control and ownership, but also impact taxation, liability, regulatory compliance, and employee treatment, as well as post-deal integration. So what are the broad categories of M&A deal structures then? The first one is asset purchase. So in an asset purchase, the buyer acquires specific assets and optionally certain liabilities of the target company. The legal entity of the target continues to exist post-transaction, unless it is dissolved by the seller voluntarily. So let's get on into understanding how exactly an asset purchase transaction looks like. The first is the legal form. So the buyer and the seller enter into an asset purchase agreement detailing each acquired asset and the assumed liability respectively. The second bit of things will be the target assets, which will mainly include physical assets, or may include rather physical assets, which is like land, equipment, etc. Intangible assets like intellectual property, contracts, etc. And operational elements, which may include inventory, receivables, etc. Then, as far as selective liability is concerned, the buyer can choose which liabilities to assume, which makes the structure attractive for avoiding unknown or contingent obligations. So many a times in M&A, it so happens that disclosures are advertently or inadvertently not made completely, or at the same time, there's always a line of defense that a seller can undertake that requisitions were not made effectively or or not sought in a manner that required disclosure apart from whatever is legally mandated. As a result of which, the buyer may be at a significant disadvantage many a time for the purpose of understanding what exactly will be conferred upon them as liabilities or prospective obligations because of pre-existing liabilities or contractual obligations that are yet to be fulfilled.
Sir, you're muted.
I am so sorry. I don't know how that happened. Is that why, Yash, you raised your hand? I was going to.
Yes, sir. That's why I did.
Oh, sorry about that. I was going to take your. I thought it was a doubt. I was going to take it after what I said. What did I mention last?
So we heard till the operational elements.
Okay. So as I was saying, this I was mentioning selective liability, wherein the buyer can choose which liabilities to assume, which makes the structure attractive for avoiding unknown or contingent obligations. So what I was trying to say was, in case there is any liability that may arise on the buyer because of inadvertent or advertent non-disclosure by the seller, and then the seller can ultimately take a line of defense saying that we ultimately do not want to undertake making XYZ disclosures because A, it is not legally mandated, and B, it was not really sought after, or the requisitions were not made effectively by the buyer. And that may lead to situations where the buyer may be conferred upon contractual obligations that the seller had entered into, which they probably were not made aware. Usually this is not the case, but sometimes because of pre-existing contractual obligations in another contract that may be there, or maybe in some term sheet that would have been there in the past, the buyer finds themselves in a spot. So clarifying liabilities at the onset in an asset purchase agreement clears things off. At the same time, if there are any pre-existing disputes which may not have been indicated because of them either being dormant or them either having subsided, or perhaps them having been resolved with the prospective possibility of them being initiated again, the buyer would want to undertake, or the buyer would want to have their liability demarcated as much as possible so that they do not have issues for the purposes of how do I put this? For the purposes of operations post the transaction, to put it in simple words. Yash, correct me if I'm wrong. You all heard me when I mentioned legal form and target assets, right? As part of asset purchase agreements.
Yes, sir.
Yeah.
Okay. Thanks, Nosheen. All right, let's now come to tax implications. So in an asset purchase, the tax implications are often favorable for buyers who get a step up in asset basis for depreciation. But sellers, for that matter, may face double taxation if they are corporations, and what they would want to ultimately then rely on in a country like India is the double taxation avoidance provision in the Income Tax Act. Or at the same time, if it is a country with whom India has a double taxation avoidance agreement, they would rely on the DTA that would hence be there. Then comes consents and approvals. Of course, it requires third-party consents to assign contracts, leases, and licenses, often making the transaction administratively cumbersome, if I could call it that. And as far as the use of asset purchase goes, it is common where acquiring specific business units happens, or when a company has litigation, regulatory baggage, or legacy issues the buyer wishes to avoid. The second form of transaction or deal structure that would exist is the share purchase. So in a share purchase, the buyer acquires the shares of the target company directly from its shareholders. And the buyer hence takes control of the legal entity and all its assets and liabilities. Let's undertake a similar analysis of a share purchase as we undertook for asset purchase. As far as the legal form of this goes, there is a share purchase agreement between the buyer and the shareholders, which, as you recall in an asset purchase, that we just discussed, is where a buyer and seller enter into an asset purchase agreement. Now, as far as the continuation of the entity goes, the target entity in case of a share purchase continues to exist with all existing contracts, employees, licenses, and obligations intact. Now, as opposed to an asset purchase where you only have specific target assets, which I had mentioned to be physical assets like land, equipment, intangible assets like intellectual property and contracts, and operational elements like inventory and receivables. Then what more is needed here in a share purchase is a more extensive due diligence, because you're inheriting all the liabilities, including contingents and off-balance sheet liabilities, in the process of a share purchase as opposed to an asset purchase. Now, as far as the tax implications in this case go, a share purchase is typically more favorable for sellers, as the sale of shares is generally taxed as capital gains. And buyers, however, do not receive a step up in asset basis unless, some sort of election is made. So, particularly speaking of countries like the United States, this is not relevant to us. This is just information that I'd like to share with you. In the United States, they call it a Section 338 election. And if the Section 338 election is not made, the buyers do not receive a step up in the asset basis. Coming to the regulatory and shareholder approvals, it is obviously less burdensome since contracts and licenses remain with the same entity. And as far as the use goes, a share purchase is suitable when the buyer wants full continuity in the business, which include customer relationships, licenses, as well as workforce. We then come to what we were discussing at the start of the session, which is a merger. So a merger, as discussed, involves the statutory combination of two legal entities, resulting in the absorption of one entity into another, or the creation of a new entity. So the legal form, of course, in this case is that it is governed by specific corporate laws, which is... Yeah, sure, Tawheed, I'll do that again. I'm sorry, I'll come back to merger. Tawheed wants me to explain share purchase again. Tawheed, in a share purchase, the buyer acquires the shares of the target company directly from its shareholders and hence takes control of the legal entity and all its assets and liabilities. So this is done through a share purchase agreement, and the target entity continues to exist with all existing contracts, employees, licenses, and obligations intact. Then as far as your tax implications go, it is typically more favorable for sellers, as the sale of shares is generally taxed as capital gains, and buyers do not receive a step up in asset basis unless there is an election that is made. Yes, Yash?
So then why would an entity go for share purchase agreement rather than an asset purchase? Because in share purchase, you also take the liabilities as well, but you can avoid that in asset purchase.
But in asset purchase, you don't typically get governance rights, right? You are operating, but the corporate governance bit of it is handled by the board of the entity whose assets you're purchasing, as opposed to a share purchase when you're buying the shares of the shareholders, and therefore you're getting corporate governance rights. So the administration and the running of the business is something that you would ideally be responsible for, as opposed to an asset purchase. So where the business is headed, how much money it'll be made, how much money it'll make, a greater share in profits is obviously possible much more if you undertake a share purchase as opposed to an asset purchase. So if it's a company that you know has a lot of liabilities coming its way because of the nature of its operations, as well as past liabilities or perhaps their operations contravening the law which is indicated in passing, or if you get some internal information which is ideally not allowed, that you know for a matter that the company perhaps can come under scrutiny of the law because of undertaking operations in a concealed manner, or undertaking illegal operations in a concealed manner, then you would want to go for an asset purchase because you would avoid liabilities that way, and at the same time, if not make a significant amount of profit, obviously get a share or get benefited in the revenue that is thereafter made. But if you know that a company is functioning effectively and they're operating within the garb of the law that is there in that respective jurisdiction, you would definitely then want to go for a share purchase, because you will get the corporate governance rights, and looking at the company's potential, of course, you can steer it the right way considering the workforce that they come with and the technical support, that the infrastructure that the company has, as well as any intellectual property that the company has. So you know that you can steer the company in the right direction, and of course generate much more revenue utilizing its potential to the fullest.
All right, sir. Thank you.
No worries. Tawheed, is your question is Asrar says, can
Yes,
you
sir.
talk?
Yes, sir. Yes, sir.
Thanks, Tawheed. Can you talk a little in Hindi also? This is a little difficult for me, but yeah, I will try my best wherever I possibly can. Whatever you don't understand, you do one thing, Asrar, you type it on chat and I will repeat it in Hindi for you, if that's okay. I'm sorry, my Hindi is not all that great. I'm a South Indian myself, but yeah, if you can just put it on chat if you don't understand anything, and I'll definitely do that.
No, sir. It's not about Hindi, sir. Like I missed some gaps in that.
No.
shared
I'm talking
purchase
about us.
only.
I'm talking to Asrar. He has also sent a
Okay.
message. Okay, thanks, Tawheed. All right, let's come back to merger. So merger involves, as I have mentioned, the statutory combination of two legal entities, resulting in the absorption of one entity, into another, or the creation of a new entity in case of an amalgamation. So the legal form, of course, as I was mentioning, is governed by specific corporate laws, which in India, of course, will be the Companies Act of 2013, or in the US, like in USA, it is obviously state-based. Like the most controversial one recently being the DGCL of Delaware. And mergers usually require a plan of merger, a shareholder approval, and sometimes a court or a tribunal sanction. So let's understand the types of merger that are there. Then 3 types that you all can note down. First is a forward merger, wherein the target merges into the buyer and target ceases to exist. Then comes the reverse merger, where the buyer merges into the target, which is common in public listings. Then comes a triangular merger, which is the most complicated one. Just pray to God that you don't do a triangular merger if you join a corporate M&A team, because in this case, a subsidiary of the buyer is used to merge with the target. So what the effect will thereafter be in case of merger is that all assets and liabilities of the target are automatically transferred by operation of law. And the tax treatment in this case varies, and statutory mergers usually qualify as tax deferred reorganization under certain laws. And where is it used? It is used when automatic succession of contracts and obligations is desired, especially in regulated industries or public companies. The next bit that we need to understand is a few things that will constitute what we call as hybrid and complex structures. This is an introductory class, so don't worry too much about it. We will obviously get into details in each and every one of these in the subsequent classes. But I will just like to list it out to you as a primer to what we are going to study in the coming classes. The first, before I come to that, a hybrid or a complex structure usually refers to a blend of aspects of these primary structures to meet strategic objectives. What I'm trying to say is that these would involve perhaps a combination of entities which are already part of existing corporate structures, and these are companies that are perhaps absorbed into one, or are held as subsidiaries by one particular holding company, etc. So let's get a quick understanding through examples. I don't want to complicate it any further, so let me just quickly give you the examples. It might be sounding like rocket science right now, so I think the examples will help. The first is, let's start with asset stock hybrids. So basically, this is where some shareholders sell shares and some assets are sold separately to optimize tax or limit liability exposure. Then comes the earnout structures, where part of the purchase is contingent on future performance metrics. The third, I think I'll mention contingent value rights, which is basically used in public M&A to bridge valuation gaps. The fourth is, of course, as you all may be aware, joint ventures, but with an option to buy. Because sometimes parties enter into strategic joint ventures with pre-negotiated call or put options. And leverage buyouts is the last example I'd like to give you here, which are often structured as stock purchases, but funded primarily by debt taken on the target company's balance sheet. With these being a few quick examples, let me quickly get into telling you what key structuring considerations would ideally be for anyone who's thinking from not a legal standpoint, but from a money-making perspective. But before that, are there any questions with regard to hybrid or complex structures? It's a little too much, I also felt. I shouldn't have probably mentioned it at this stage. But are there any questions? Does anyone know what call and put options are, by the way? When I mentioned joint ventures with option to buy, I mentioned call and put options. Does anyone know what call and put options are?
Yes, sir.
Go for it.
Sir, actually, buyout means like the existing shareholders has a right to first buy their shares. Like, for example, the 50 shareholders and the other 25 shareholders wanted to sell their shares, and the existing 50 shareholders has the right to take that shares, and that 25 shares that wanted to sell it, the first instant जो existing 50 shareholders है वो उनको ही देगा.
Correct. नहीं, आप सही बोल रहे हो. It's right. Good, Sharmila. I mean, I'll put it better, but you know the concept. That's good. Anybody else? Okay. Let me quickly give it to you. So call and put options are ideally what we call derivative contracts, and these are used in stock and commodity markets, and this is governed by the SCRA, that is the Securities Contract Regulation Act of 1956. So what are call and put options? Very simply, call option, as Sharmila mentioned, gives the holder the right but not the obligation to buy an underlying asset, that is like, shares of a company, at a specified price within a specific period of time. Now, put option, on the other hand, gives the holder of the shares the right to, but not an obligation, of course, to sell an underlying asset at a specified price within a specific period. Now, as opposed to a forward contract wherein you agree to buy something at a future price, I mean, as at a future point in time at the current price determination, the prices of these are ascertained, and it is you are allowed to buy it or sell it within a specific period of time as a matter of entitlement, and you are not mandated. You can waive off this right as well. So you have the option of what I'm of just saying that I do not want to buy it because now I don't want to exercise this right anymore. So then you can choose to not, as opposed to a forward contract, which are illegal in India at this stage, where you are mandated to buy it at a futuristic point in time at a price that is predetermined. So these are what call and put options are. Let's come back to what I was talking about, which is key structuring considerations. So when determining the structure of an M&A deal, the parties must consider a wide range of legal, tax, and regulatory factors. What do I mean by this? Let's list them, right? So first will be tax efficiency. So which will be a setup in basis or capital gains treatment, VAT indirect tax impact, and international tax implications, all of which will affect your choice. The second, and one of the most important considerations, is liability exposure, because buyers prefer structures that limit unknown liabilities like asset purchase, while sellers prefer clean exits, which is like a share sale. Then comes regulatory compliances, which will basically be your licensing laws, foreign investment controls, and antitrust regulations, which may favor one structure over another. Then comes your third-party rights, so which will basically be contract assignability, change of control clauses, and union or labor considerations that which may impact structuring. The fourth will be employee retention. The fifth will be employee retention, which will basically be share purchases and mergers, which will allow for easier employee retention without the need for reissuance of offer letters or contracts. I mean, when I say contracts, obviously, as you all know, I mean employment contracts. The sixth would be financing considerations, which is basically how the transaction is financed, which often shapes the legal structure due to implications on control and shareholder dilutions. The seventh will be cross-border complexities, which will basically be your domestic corporate laws, your foreign exchange restrictions, and treaty benefits, which often dictate the appropriate structure. Then how is deal structuring influenced legally in India? This is what we're ideally looking for. The first is your Companies Act of 2013, which will govern your mergers, arrangements, or amalgamations. Particularly relevant, of course, but not only, will be sections 230 to 232 of the Companies Act of 2013. The second will be your Income Tax Act of 1961, which will basically affect your capital gains transactions or your capital gains taxations, I mean to say, or your carry forward of losses and transfer pricing. The third, of course, will be FEMA, the Foreign Exchange Management Act, and the rules and regulations thereunder, which will limit and give conditions for foreign investments in M&A transactions. Then comes your SEBI regulations, especially for public listed companies, including your SAST, which is substantial acquisition of shares and takeovers regulations, your insider trading regulations, as well as your LODR norms, that is listing obligations and disclosure requirement regulations. Then last but not the least is your stamp duty and GST. Asset transfers may attract higher duty and GST compared to share transfers. So that is also a decisive factor, but obviously not something that is very pressing. Let's now get into detail on what the legal framework is. So the Companies Act of 2013 serves as the foundational legal instrument for structuring corporate M&A, especially mergers, demergers, and schemes of arrangement. So key provisions will definitely be sections 230 to 232, which will govern compromises, arrangements, amalgamations, and mergers. And these sections prescribe a tribunal-driven process, which will involve four things. First is the application to the National Company Law Tribunal, that is the NCLT. Second is your creditors and shareholders meetings. Third is your regulatory no objections, which will respectively be from the regulatory entities like SEBI, RBI, CCI, Registrar of Companies, etc. And then, of course, if required, any judicial scrutiny of fairness, minority protection, and public interest as may be needed from time to time. Then you have your fast track mergers, which, if I'm not wrong, comes under section 233, which provides for a simplified route for intra-group mergers involving small companies or wholly owned subsidiaries, which will basically avoid your NCLT involvement. We will discuss this in detail in the coming classes. Then comes section 234, which governs your cross-border M&A, both inbound and outbound, with prior RBI approval. So the RBI foreign exchange management cross-border merger regulations prescribe how assets, liabilities, and securities will be treated in such mergers. So before I continue, I mentioned inbound and outbound mergers in the context of cross-border M&A. Can somebody tell me what inbound and outbound mergers are if you're aware? Unmute and speak. You don't have to raise your hand. Anybody? Nobody? That's a surprise, yeah? Okay, let me give it to you. So an inbound merger is where a foreign company mergers into an Indian company and the resultant entity is an Indian company. An outbound merger is where an Indian company merges into a foreign company and the resultant entity is a foreign company. It's as simple as that. And you also have under the Companies Act, Section 186, which imposes limits on intercorporate loans. And I mean, actually a lot of sections between 180 and 187. But you need to understand that there are limits that are imposed on intercorporate loans and investments that may arise during M&A deals specifically, which comes under Section 186. But of course, intercorporate loans otherwise is largely regulated between 181 to I think 188. 188 is related party transactions. Sorry about that. 181 to 187, perhaps you might want to check it. Then comes your SEBI regulations. So when the target is a publicly listed company, the Securities Exchange Board of India plays a pivotal role in through multiple regulations. Let me present it to you. The first will be the takeover code, or as we call it, the SEBI SAST regulations, which is SEBI Substantial Acquisition of Shares and Takeover Regulations of 2011. So what this does is, you can note it down, it does three things, mainly for M&A purposes. It mandates open offer obligations when an acquirer crosses specified shareholding thresholds. So what it specifies the shareholding thresholds to be is 25% and then subsequent 5% increments. It then regulates indirect acquisitions, change of control, and creeping acquisitions. It also protects minority shareholders through exit offers and price discovery mechanisms. The next is the SEBI LODR regulations of 2015. That is to say, the SEBI listing obligations and disclosure requirement regulations of 2015. For this, you can note down two things. First is that it requires timely disclosures of M&A announcements, board decisions, and shareholder approvals. Second, it imposes conditions for schemes of arrangement, including valuation fairness, or valuation fairness options. I'm sorry, I correct myself. Stock exchange approvals and audit committee oversight. The third will be the SEBI delisting of equity shares regulations of 2021, which is basically relevant for acquisition-driven delistings, post-mergers and acquisitions, especially in perhaps leveraged buyouts or squeeze outs. Then comes your SEBI issue of capital and disclosure requirements, regulations of 2018, which just comes into play when acquisitions involve preferential allotment of shares or warrants as consideration. This is not a very significantly important regulations. This is not a very significantly important regulation to M&A, but only and only if there are preferential allotments in the process of acquisition will the ICDR come as relevant. The next set of regulations that we have is the FEMA, and which governs foreign direct investment and overseas direct investment in M&A specifically. Mergers and acquisitions specifically. I'm sorry, I correct myself. Mergers and acquisitions is what I meant to say. I'm sorry, I correct myself. Okay, let me think of how do I present this to you a little simply, because usually it's very complicated. So I don't want to, like in the first class, just give a lot of legal lingo unnecessarily without context. Okay, let me put it this way. So FEMA and the associated rules or regulations issued by the Reserve Bank of India regulate foreign investment in Indian entities and outbound investment by Indian entities. And the main guidelines that will come into place are firstly your FEMA NDI rules 2019, that is FEMA non-debt instruments rules of 2019, which basically prescribe the sectoral caps, pricing guidelines, and government route approvals for FDI. You then have the FEMA overseas direct investment rules and regulations of 2022, which govern Indian entities acquiring businesses or setting up subsidiaries abroad. The third will be your pricing guidelines. That is, in case of acquisition of shares by non-residents, minimum pricing norms based on DCF or valuation reports are mandatory. And the last, of course, will be your RBI approval, which is required for transactions in sectors with FDI restrictions, like your defense or media, or for cross-border mergers, as provided for under Section 234 of the Companies Act. Then your downstream investment compliance is also important because it ensures that foreign-owned Indian companies acquiring or investing in other Indian entities comply with indirect foreign investment rules. Then for the purposes of antitrust clearance, you have the Competition Act of 2002, which basically provides for, the Competition Commission of India to review M&A deals that cross your specified asset or turnover thresholds that are specified under Section 5 and Section 6 of the Competition Act of 2002. So what CCI basically does is it looks at merger control, it looks at regulation of your combinations or acquisitions, and then it has an assessment criteria. In this, we will also speak about your green channel route, which was introduced in 2019. So let's start with merger control. So merger control basically means if there are deals which trigger thresholds as mandated under Sections 5 and 6 of the Competition Act of 2002, they must be notified to the CCI by the buyer before implementation, and at the same time, it is also regarded as a mandatory pre-closing approval. If there is a suspicion of thresholds being triggered. As far as combination regulations go, they detail filing requirements, exemption categories, and set your timelines. When I say exemption categories, let me give you examples here. These are intra-group restructurings or minority acquisitions below 10%, etc. Then comes your assessment criteria, where the CCI evaluates whether the combination causes or is likely to cause an appreciable adverse effect on competition in India. That is what we call as AAEC. Can somebody tell me under what section AAEC is defined and what AAEC is? Let me make this a little interactive. Come on, I think AAEC is very simple. All of you all are law students. Yeah, you all have read this. Nobody? Okay, let me give that to you. AAEC is not, AAC is not directly coming under, coming directly under the garb of the Competition Act of 2002. It comes as, it comes as a part of restrictions on anti-competitive agreements that is prescribed under Section 3 of the Competition Act of 2002, wherein the, anti-competitive agreements, including those that cause an appreciable adverse effect on competition, are declared to be void. I think for more context, you can look at sections 3.2 and 3.3 of the Competition Act of 2002. Okay, let's come back to what we were discussing. The green channel route, which I was attempting to mention, it was introduced in 2019, and it allows for deemed approval in cases with no horizontal, vertical, or complementary overlaps. So, what I'm trying to say is, if there is no threshold being triggered significantly, or if there are no overlaps that are there and after created, then you would ideally want to you'd ideally not want to get an approval, and you will understand that the approval is deemed to exist. You can continue with the transaction without the CCI approval. You will not come under scrutiny of the CCI. CCI has suo motu powers, as you all may be aware, so you will not come under the scrutiny of the CCI. Then comes your Income Tax Act of 1961, which basically gives context for taxation of M&A transactions. So tax treatment of M&A deals varies significantly depending on the structure. As we discussed, it's different in case of asset sale, share sale, or mergers. And if you recall, in one case, it is just merely, in case of asset sale, it's simpler on the buyer, and there's a double taxation risk for the seller. And in case of sale of shares, it's easier, or it's less heavy for the seller, and it is mainly gain tax as a capital gains tax. So let's discuss this in 4 points. First is your capital gains tax, which is basically applicable on sale of shares or assets, and indexation and exemptions under Section 47, which provides for tax neutral mergers or demergers, also play an important role here. Then comes your Section 72A, which allows for carry forward of accumulated losses or unabsorbed depreciation in case of amalgamations, subject to specific conditions. Then comes your transfer pricing, which applies, under Section 92AF, which applies in cross-border deals and intergroup restructuring to ensure arm's length valuation. Then comes your GAR, or General Anti-Avoidance Rules, which may apply to tax-motivated restructuring and hence lacking commercial substance. So tax-efficient structure requires early-stage analysis to assess indirect transfer provisions, MAT implications, and potential for deferral or exemption. Then comes your labor and employment laws, where I would like to highlight that M&A deals often involve the transfer or restructuring of employees, and it is governed by many legislations. We have ton of employment legislations in India, and we will continue to have them till the labor codes come into place. So mainly you will firstly have the Industrial Disputes Act of 1947, which will require notice and compensation if workmen are laid off during a business transfer. Then you have the respective Shops and Establishments Acts and rules of the respective states, which may trigger re-registration requirements if offices are relocated or new business entities are formed. Then, of course, you will have gratuity, provident fund, and ESOPs, which will basically mean that there will be continuity of service and fund transfers ensured during asset purchases or mergers. You then have, of course, your industry-specific and sectoral laws that will come into place, which will basically be if you're part of the BFSI sector, you will be governed by the Banking Regulation Act of 1949, and of course, RBI approval is mandatory for all amalgamations. For insurance, of course, you will require IRDAI approval, the Insurance Regulatory Development Authority of India. Regulatory and Development Authority of India. I'm sorry, I correct myself. And this is as required under the Insurance Act of 1938. Correct me if I'm wrong. This is what I exactly recall. And the IRDAI scheme of amalgamation and transfer of business regulations. Then, of course, for telecom, you need your Telecom Regulatory Authority of India and Department of Telecommunications permissions under the unified license conditions. Then under real estate, you will have RERA compliance and stamp duty challenges in asset-heavy deals. Then, of course, for your distressed companies, you will have the Insolvency and Bankruptcy Code of 2016 to be relevant, particularly through perhaps first Section 31, which provides for a binding effective resolution plan approved by the Committee of Creditors and the NCLT. This then comes Section 29A, which will restrict, ineligible bidders, let me put it that way. I think that's what they're referred to as especially your promoters of defaulting companies. Then comes your pre-package and liquidation sales, which offer a new route for asset acquisition. Then, of course, your fast-track processes. Which will enable quicker M&A for micro and small enterprises. That brings us to the last topic of today, which is very, very important. I think it's one of my most favorite topics in mergers and acquisitions, because I think this is where the fun is. Otherwise, corporate in itself is a little too monotonous, for the lack of better language. We come to real world negotiation. So negotiation and drafting strategies in M&A transactions involve a careful balance of legal precision, commercial acumen, risk allocation, and stakeholder alignment. So unlike routine contracts, M&A deals are high stake, high value, and layered with uncertainties, which range from valuation disagreements to post-closing integration issues. So the strategies adopted during negotiation and drafting are thus not merely mechanical, but are shaped by deal size, industry dynamics, leverage between parties, due diligence findings, and regulatory risks. So what exactly would a negotiation and drafting therein after involve? I asked it as a question. Does anyone have an answer? In your opinion, what does it involve? Never mind, I'll give it to you. So it has a number of things. Let's start with ranging from pre-negotiation to due diligence to post-negotiation. So let's start with pre-negotiation. So what this pre-negotiation planning is basically where you anchor the deal, like make the deal solid and strong. right? So you start with a term sheet or a letter of intent. That is to say, a non-binding letter of intent will lay the foundation by capturing key commercial terms like valuation, consideration structure, like, sorry about that, consideration structure, exclusivity period, due diligence window, and governing law. So though not binding, uh, letter of intents often contain binding provisions such as confidentiality and no-shop clauses. Then you have your strategy in this, wherein the buyer side should use the letter of intents to lock in exclusivity and define broad parameters of control change or indemnity thresholds early. The seller side should seek to keep letters of intents vague, or letters of intent, I'm sorry, I correct myself. I'm sorry, my bad, I correct myself. I mean, sorry. Vague on warranties and indemnities and push for time-bound exclusivity. And for the purpose of leveraging timing, negotiators often time the letter of intent often time the letter of intent finalization or draft execution with key financial disclosures like quarter end statements, business wins, to enhance or protect valuation. Let me repeat, your negotiators will often time letter of intent finalization or draft execution with key financial disclosures, which will basically be quarter end statements or business wins, to enhance or protect valuation. The next will be a due diligence driven risk allocation, which is basically a thorough legal, financial, tax, and operational due diligence should be undertaken for the purposes of your risk mapping. So the negotiation outcomes are often shaped directly by diligence red flags, as we call them. So the strategy would be the buyer side lawyers should classify risks into deal breakers, warrantable issues, or price adjustable risks, which in legal lingo we say red flag issues, orange flag issues, or yellow flag issues, and green flag issues. So deal breakers are high risk issues, which really need to be supported through a pre-closure change. Then comes your warrantable issues, which can change pre-closure or post-closure, for post-closure you can just take a representation and warranty from the seller. And price adjustable, mostly these are post-closure items for which you can take representations and warranties from the seller. Then comes your seller side advisors, who may proactively disclose the known issues via disclosure schedules to limit indemnity liability. I mean, ultimately, it's also good for a seller, right? If there's if you're balancing and at the same time there are issues that are really pressing, but at the same time that's so profit making that your issue resolution is going to be a marginal cost post the transaction, then you would want to take it up as a buyer. But at the same time, you also want to be indemnified. But obviously, certain things the seller may negotiate and say that we can't indemnify against this because this is a significant risk that we would not want to bear the costs of post a transaction because of whatever financial reasons may surround it. So in that stage, of course, then the buyer might want to go for it, and the seller, of course, has made full disclosure. And because it's such a significant risk, the seller will not be responsible post the transaction. Whatever liability to whatever extent that may come into place will fall on the buyer after the transaction. Then comes negotiating the purchase agreement, in which we follow what we call a clause by clause strategy. So the first will be what I mentioned to you, the representations and warranties. So the buyer strategy will be ideally to demand broad representations and warranties, particularly on title, compliance, tax, intellectual property, material contracts, and litigation. The seller strategy will be to seek qualified representations and warranties using to the best of knowledge. It's like a line of defense. Like you have journalists who put question mark in the ends of news articles. To the best of knowledge is like a line of defense. But of course, courts have time and again come into place and said that to the best of knowledge does not act as a complete indemnity to you. You will have to still act in good faith and undertake undertake your disclosure exercise to the to the best possible extent. And at the same time, the representations and warranties will also use materiality thresholds and specific carve-outs in disclosure schedules. What we also have one more concept that we have is which is what we call sandbagging clauses. And sandbagging clauses are used to address post-closing claims where buyer knew of an issue but still proceeded. Which is what I was telling you, right? Like if there's so much of profit making and at the same time there are also great extent of liabilities, but it is a marginal cost in comparison to the profits that you will be making. And of course, you have a way to get around these liabilities. Then, I mean, if you bite the bullet, then you know as a buyer, you will definitely want to, you'd want to indicate that you're aware, and thus you would want to attract the seller would not want to attract liability after the closure of the transaction. That is when sandbagging clauses are used. Second comes your indemnities. So this will identify or encapsulate three things. First is your survival period. Second is your caps and baskets. Third is your escrow and holdbacks. So on survival period, a buyer may ideally push for 2 to 3 years, while seller aims to match the statute of limitations or shorter durations. Then comes your caps and baskets, wherein your caps, for example, 10 to 20% of purchase price, limit seller's total liability. Baskets like deductible versus tipping create claim thresholds. Then comes your escrow or holdbacks, wherein the buyer may negotiate an escrow amount of maybe 5 to 15% to be held for indemnity claims. So usually an RWI insurance is used in high value or auction deals to replace or reduce the seller's indemnity burden. Then comes your conditions precedent, which will basically be your like regulatory approvals like CCI approval, RBI approval, NCLT, third-party consent, debt clearances, and employee transitions. Then comes your, a strategy where the buyer may seek detailed conditions precedent lists, and sellers prefer only essential conditions to prevent post-signing delays. Then you also have certain types of concerns that we can have here to address through what we call hell or high water clauses. So this is when the buyer must obtain antitrust clearance regardless of the burden. So you just want to be safe and you want to ensure that there are no legal liabilities. So you undertake your regulatory approvals, and for the purposes of mandating the same as conditions precedent, you indicate it through hell or high water clauses. Then comes pricing mechanisms, and we will mainly look at two mechanics here. One is the locked box mechanism, and the second is closing accounts mechanism. So the locked box mechanism involves the price being fixed on a historical date, with the seller bearing economic risk post that date, and it is usually preferred in seller-driven deals. A closing accounts mechanism, on the other hand, is where the purchase price is adjusted post-closing based on the working capital, debt, and cash levels, and it is preferred by buyers. Then comes a negotiation focus. Adjustments, methodology will be one important thing. Definitions of cash, debt, and working capital is also important. And lastly, dispute resolution mechanism or the auditor's rule is also important. Then we have smaller and minuscule aspects that I'll quickly cover up. I'm sorry, I know I've taken your 1 hour. I would just need like 10 to 15 minutes more. Your first of the next will be earnouts or deferred consideration. So this is basically used when there is disagreement on valuation, particularly in service-based or intellectual property heavy businesses. The strategy here is that the buyer link earnouts to EBI, TDA, revenue, or customer retention. Then comes your seller strategy, wherein the seller ensures metrics are realistic and not susceptible to post-acquisition manipulation. And this basically will involve insertion of anti-diversion covenants. So what this basically will include is audit rights, acceleration clauses, and dispute forms for earn-out disagreements. Then you have your non-compete, non-solicit, and retention provisions, wherein your non-compete basically will last for 2 to 5 years post the deal. But courts in India, of course, scrutinize such clauses under Section 27 of the Indian Contract Act to be restrictive covenants. So a lawyer must ensure that they are reasonable in duration and geography. Then comes your non-solicit clause, which will often be broader and more enforceable than non-compete. Then comes your employee retention, wherein you would use retention bonuses or transitional service agreements to retain key talent. I think the next thing that I'd like to talk about is your tax structuring and stamp duty planning. So a legal counsel and or tax advisors or both collaboratively plan the transaction route if they work together. Of course, they collaboratively plan is what I'm trying to say to optimize for the taxes that we've discussed, which is basically your capital gains tax, your indirect tax implications in asset transfers, stamp duty, and transfer pricing. Okay, wait. Let me clarify from the start. Capital gains tax will include resident and non-resident sellers, and you'll ultimately want to identify implications accordingly. Then your indirect tax implications and asset transfers will also be in place. Then your stamp duty is important, especially in slum sales or property transfers. And then comes your transfer pricing issues in group reorganizations. So you basically use step-down subsidiaries, share swaps, or slum sales tactically to reduce cost and regulatory hurdles. Excuse me. Then comes your regulatory filings and timelines. I have said this multiple number of times. I will just reiterate it. You will have to coordinate your pre-closing filings. That is your FDI approvals, your CCI combinations, NCLT petitions, and SEBI filings to align with the condition precedence timeline. You will have to incorporate long stoop dates, reverse your break fee, and risk allocation for delay and regulatory approvals. And of course, in cross-border deals, you will have to navigate multi-jurisdictional approvals with synchronized closing mechanics. Then, of course, you have your escrow, holdbacks, and earnouts. Very simply, for your, as I had mentioned, 5 to 15% of the amount for your indemnity claims, performance-based holdbacks, or deferred payouts. Usually, as part of strategy, I'm sorry, I correct myself. They use third-party escrow agents. Let me not get into very much detail. That's why I was thinking hard about how to put it out to you. They use third-party escrow agents with clearly negotiated release conditions. So when I say release conditions, what I mean to say is, if on non-fulfillment of condition precedent, you make an assessment of the liability that may be incurred, and that basis that liability, you agree upon the amount that has to be released by the escrow agent, which will then be utilized towards remedifying that liability. So in India, RBI guidelines must be followed for cross-border escrow and payment structures. Then last but not the least, your dispute resolution and governing law. So cross-border deals often adopt Singaporean law of late with arbitration under the Singapore International Arbitration Center. And I've also seen English law being adopted and the London Court of International Arbitration also being utilized. And these stand to be robust, but I think Singapore is the most, arguably the most arbitration-friendly jurisdiction. So I think Singaporean law and SIAC is ideal for cross-border deals. Domestic deals obviously will embrace Indian law and arbitration under the Arbitration and Conciliation Act of 1996. I'm sorry, correct myself. Then you will, ideally as a negotiator, you will have to negotiate 3 things for dispute resolution. First is a very, very clear seat of arbitration. Second is your language. And third, if needed, you would want a multi-tier dispute resolution mechanism, which is basically what we call MEDAB or mediation arbitration. That is, you'd want to have the dispute settled amicably, attempt to have the dispute settled amicably first. And if that doesn't work out, then the dispute gets referred to arbitration. So let me quickly revise it for you. Your first will be your pre-negotiation and deal structuring strategy, which will basically be commercial alignment before your legal drafting. Then comes your, which will basically include your tactical approach, where you would insist on a detailed term sheet or letter of intent, which will identify your price and payment structure, exclusivity period, key warranties and indemnity principles, and your conditions precedent. Then comes your negotiation of core deal elements. This will basically have your valuation and pricing mechanism strategy, and there will be the two dominant approaches that we discussed. That is the locked box and closing accounts mechanisms. Then you have your earn-out clauses, which will bridge the valuation gap, wherein the buyer strategy will be to tie earnouts to EBITDA, EBITDA, or that is to say, or revenue metrics with tight definitions and audit rights. And this will include anti-manipulation clauses to avoid seller gaming. Then you have your seller strategy, which will push for operational autonomy and acceleration clauses if the business is sold or key milestones are achieved early. Then we had looked at representations and warranty strategy, wherein the buyer strategy will be to push for bring down of representations and warranties at closing. And then you will also demand broad and specific representations and warranties for litigation, tax, licenses, intellectual property, and environmental compliance. And you would prefer absolute terms as a buyer, like the company is in compliance, over qualified ones like to the best of knowledge. But as a seller, you would want narrow representation and warranty using qualifiers like material, actual knowledge, reasonable efforts, or the biggest defense, as I mentioned while discussing this, to the best of knowledge. You would avoid forward-looking representations and warranties and use detailed disclosure schedules to carve out exceptions. And at the strength of the representations and warranties directly determines your indemnity risk, your escrow size, and your survival periods. I'm sorry if I'd forgotten to mention that earlier. It just came by, so I mentioned. We had then discussed your indemnification strategies, where the buyer would want, the indemnification strategy would be negotiated intensely because it governs post-closing liability, and the buyer usually calls for a broad indemnity coverage with longer survival periods and lower baskets, and as well as higher caps, and of course did not want a de minimis thresholds for large claims. By long survival period, as I had mentioned, I meant statute of limitations or at least 18 to 24 months. Lower baskets, I meant threshold before claim allowed. By higher caps, I obviously meant maximum liability. And as far as the seller goes, you push for tipping baskets, that is claims only after aggregate loss crosses basket. Then comes low cap, which is for a seller, which is 10 to 20% of the share purchase price. Then your sunset clauses to limit duration, and of course carve-outs for fraud and intentional misrepresentation. And the RWI, that is the representations and warranties insurance, can be used to bridge negotiation deadlocks on indemnity and caps, especially in private equity deals. We had then discussed your conditions precedent and long stop dates, wherein the buyer adds conditions precedent for third-party consents, regulatory approvals, no MAC, no MAC event, and no breach of warranties. And the seller limits conditions precedent to essentials, avoids, if I can put it this way, I've written it, buyer satisfaction language, pushes for a backstop date, and reverse termination fee if the buyer delays. And a very simple example, let me put this to you. This is what I've written down. Sellers may demand automatic closing if conditions precedent are met and buyer doesn't close within the agreed number of days, which should be reasonable. Excuse me. Then comes your risk sharing and liability management, wherein your escrow and holdback strategies will come into place, wherein escrow accounts are used to secure buyers' claims post-closing. Buyer seeking to provide 10 to 15% escrow. I'm seeking 10 to 15% escrow for 12 months, and sellers negotiating shorter duration, lower percentage, and clear triggers for release. And of course, third-party escrow agents may be used with dispute resolution clauses, and RBI guidelines will apply for cross-border escrow in India. Then the simpler ones being non-compete and non-solicitation. The strategy will be to keep the clauses limited in scope, the duration being reasonably for 2 to 3 years, and of course, keeping in mind the geography. Then drafting it as a necessity to protect legitimate business interests and considering partial interests like product line or territory, and the risk of Section 27 of the Indian Contract Act 1872 that I had mentioned, which wherein Indian courts will view non-compete clauses scrutinize non-compete clauses basis this section, and they will render it invalid if unless it is part of a sale or business goodwill, if it is unreasonable. Then your change of control clauses and third-party consent, that is, in real-world deals, third-party contracts may have change of control restrictions, and your drafting strategy will be to include representations that no material contracts require consent or pre-obtainment of these during signing to closing period. And for buyers, you insert walkaway rights or price adjustments if not obtained. Then, of course, we discussed your tax-efficient structuring, wherein you choose between a share sale, asset sale, or slum sale based on your stamp duty incidence, your capital gains tax, your GST or VAT implications, etc. Then comes your regulatory approvals, wherein you have to look at your CCI approvals as may be needed. That is your pre-closing approval if the thresholds are crossed. Then your RBI approval for foreign remittance, pricing guidelines, and sector caps. Your NCLT approval for merger and amalgamation under Companies Act of 2013, and SEBI approval for takeovers, delisting, or restructuring involving listed companies. Then comes your arbitration, your dispute resolution, and for the arbitration clause negotiation, you would want to ensure that there is a fixed seat of arbitration. You decide on an institution, or whether you want it as an ad hoc, and a multi-tier dispute resolution clause is maybe inserted if needed, if you'd want to attempt to amicably resolve the dispute first and then go into arbitration. And you might want to also consider including, I'm sorry if I forgot to mention this earlier, survival clauses, assignment rights, and governing law clauses that align with the business context. And one last thing I'd like to mention here before I end my lecture for today is the importance of soft skills. This is nothing legal. This is just a takeaway that all of you would want to consider. So what I mean to say by soft skills is a convincing ability to be firm, yet not leveraging. Yet not non-leveraging. That is to say, you don't give up on your position, and at the same time continue to be convincing and toned in demeanor. So managing deal emotions and dynamics is where this comes is important, because if founder-driven sales are in place, you need to understand that they often involve emotional attachment, and lawyers must be sensitive. And at the same time, private equity buyers have high standards for governance, warranties, and performance governance with focus on precision. So your strategy should be, first, to avoid adversarial tone and red lines. Second, use joint calls to explain major red line disagreements. And third, allow face-saving exits. That is, industry practice requires us to ask this. Like, don't ever not use language like this. So you need to allow these face-saving exits, and I meant to say avoid non-face-saving exits. I'm sorry if I mentioned avoid face-saving exits. It's avoid non-face-saving exits and allow face-saving exits. So you don't have to say why exactly it's triggered. You need to mention it as part of larger industry practice, and then ultimately give that as a reason to ask what your client intends to be clarified with or be provided an answer to for the purposes of taking a strategic call. So this is how you exactly bring about your soft skills effectively in a negotiation for a merger and acquisition to ensure that the buyer comes your way and you are ultimately benefiting the seller. That brings me to the end of the lecture for today. If you have any questions, I'm happy to take. Sorry, overshot my time like anything. I didn't intend to. It was just very, very demanding. So I went above the time by 20 minutes. I apologize for that. I don't see that there are any other questions. I hand it over to you, Shriyanshu.